Welcome to week one, everybody. I have put together weekly video slash PowerPoint presentations for all of you in the hope that it will help you navigate through the course itself, but also have a baseline understanding of the criminal justice system and give you some familiarization for each chapter. One thing I have discovered, and I'm not sure if this is still the case this quarter, but last quarter, several of my students had textbooks that were missing chapters 2, 5, 6, and 12. I want you to understand something. The final exam contains 50 questions, and 11 of those questions come from those four chapters that are actually missing from your textbook. So what I have done is I've put together weekly lectures um, which will include information that is missing from your book, but will help you so that you can get 100% or hopefully 100% on your final exams. I just don't believe in having students take a class but then not give them all the tools necessary to succeed. So, that being said, I put together this about a 12 slide PowerPoint presentation and we'll kind of rip through this real quick. The theme of our textbook is individual rights versus public order, which is public order is kind of the same as public safety, society safety, that type of thing. Individual rights is pretty self explanatory. A person's rights versus the safety of society. Okay. We have two types of advocates. An individual rights advocate is one who seeks to protect the personal freedoms within the process of the criminal justice system. And the public order advocate is one who believes that under certain circumstances involving a criminal threat to the public safety, the interests of society should take precedence, or it's more important than a person's rights. So here's an example I'll use. How about back in San Diego, I don't know, maybe it was a year ago or so, there was a gentleman who was trying to get onto a flight. And prior to getting onto the flight, he had to go through their security system. And San Diego Airport had just obtained one of those new, I think it's a X-ray machine. At any rate, when he got to the security system, he did not want to walk through this X-ray machine and basically argued with the TSA employee at the security checkpoint. What he was ultimately trying to show was that he was an individual rights advocate. He felt that his personal freedoms were being infringed upon by forcing him to go through the X-ray machine, and if he failed to do what they said, he would be arrested. Now, the public order advocate obviously is going to be the TSA employee. That's the employee who says, "Listen, you know what? We've had terrorist attacks on our country for the last umpteen years. And in order to prevent a threat to our public safety, in order to make sure that people who are coming through the security checkpoint don't have any types of weapons that could hurt or harm our public safety, your interests, your individual rights really aren't as important to me as the safety of our society." So hopefully that analogy will help you understand the difference between individual rights versus public order. Okay. After 9/11, the government's tendency really has been more or less to restrict a person's individual rights for the sake of really making society feel or be much safer. I put this picture on here, I got this off the internet, but as our country becomes more diverse, we're also going to see a lot of cultural differences. And with cultural differences, you're going to see uh, a variety of different ways people dress, act, etc., etc. Well, as somebody who works as a police officer part time, I am someone who is actually on the public safety, uh, public order side of the spectrum here. And if I were to pull this person over for speeding, so to speak, and they handed me this driver's license, I would say this driver's license to me is not acceptable proof of identification simply because I can't see who you are, and you can't prove to me that that is who you say you are. Um, so the driver would most likely feel that his or her individual rights were being infringed upon, or that I was stepping on them or restricting them or narrowing them. But at the end of the day, that is something we're going to be facing as long as we have threats to our society. It's always going to be this challenge, individual rights versus public safety. And as you learn more and more about criminal justice, you'll see that throughout the decades, the criminal justice pendulum, if you will, has swung back and forth. The 1960s was really a big individual rights era, but then by the 1980s, the pendulum swung over towards the public order or uh, safety of society. So, and who's to say that maybe 20 years from now, the pendulum isn't going to swing back to the individual rights side? We have several types of justices. Social justice is a concept that embraces all aspects of civilized life. It's linked to notions of fairness, beliefs of right and wrong. You know, civil justice is really something that is uh, a relationship between people, business, contract, obligations, etc. So, good example would be is if you fail to pay your rent and your landlord takes you to small claims court, he's utilizing the civil justice, or he's involving you in civil justice because it was a violation of a contractual obligation, so to speak. Now, criminal justice is something you're all familiar with, and that's really the concern of violations of criminal law. We can look at criminal law as federal law as long as it's pertaining to criminal and crime. We have state law that also is criminal in nature, and we have cities that have city ordinances too that are also deemed to be something that you could be cited for, which is criminal in nature as well. Um, Administration of justice is the day to day practice of the truth in action process. So we're going to focus primarily on the criminal justice type throughout this quarter. Now, our American criminal justice system has two different models. We have the consensus model and we have the conflict model. The consensus model is really a perspective that assumes that the three components of the American criminal justice system works harmoniously together to achieve a social product we call justice. And that's really fancy schmancy for saying that the three components, which would be policing, courts, and corrections, all work like a well-oiled machine to achieve a final uh, product that we call justice. Now, if you look at it realistically, I think that the conflict model is really a perspective that is better, a better description really as to how our American criminal justice system oftentimes works. This perspective assumes that the system's components function primarily to serve their own self interests. So, if you have police officers that don't apply the appropriate case law, they don't make just arrests, they are doing things that are illegal or basically arresting people without proper probable cause, without warrants. What they're doing is they're fulfilling their own self interests, but they're creating a situation where the court system itself can't function. Because if you take somebody who's been arrested without probable cause or without a warrant, that prosecutor is going to say, sorry, we're going to have to let him go. And so then that system itself is not functioning like a well oiled machine. And I think that we could also say that when the court system itself then imposes some really strange sentencing guidelines, or let's say you've got somebody who's killed three people, and that judge decides, okay, he's guilty, but now I'm only going to sentence that person to 2 years in prison. That parole or probation officer that's got to deal with that particular defendant who's only been sentenced to nothing more than a mere slap on the wrist, it doesn't really serve a very it serves the court's purposes, but it doesn't help the corrections component very well. So hopefully you get a better understanding of that. The two models that we have, again, are really very indicative of the theme of the book. I'll say that the due process model is a perspective that emphasizes the individual rights at all stages of the justice system processing. So Back in the 60s, when several landmark cases were being established by our Supreme Court, they were functioning really on a due process model. It was a model where it emphasized individual rights. Now, the crime control model would be something that you would see in the 1980s. It was a perspective that our justices used that emphasized the efficient arrest and conviction of offenders, so to speak. The criminal justice process here in America has several stages. The first stage, of course, being investigation and arrest. Before you can arrest somebody, you must have probable cause. You're taking away their freedom, so you better have a set of facts and circumstances that would lead a reasonable person to believe that another has committed a crime. Also, if a crime was committed outside the visual or outside of an officer's presence, an arrest warrant is necessary, and a warrant is basically a writ or a document issued by a judge directing an officer to perform that arrest legally. After an arrest has been performed, then the booking process is next. And a law enforcement or correctional process officially that records the entry into a detention center of the arrested person's ID or who they are, the place they were arrested, the time and date, the reason for the arrest, and the department. And ultimately, what the booking process includes is fingerprinting and photographs so that you have booking photos. And I know you can't see this, but in here you're going to see height, weight, date, sex. Um, oh, I'm not sure if there's anything else, possibly tattoos. So, but I always like these booking photos, think they're kind of funny. The next level of the process is the pretrial activities. This could include a first appearance or a preliminary hearing, or sometimes they're one and the same. The first appearance is done within the first few hours after a person's arrested. This is where the judge tells the individual what the charges are that are being brought against him or her, advises them of their rights, and may offer bail. So you get arrested for D-dub, spend overnight in jail. You end up going to see the judge in the morning. The judge's going to tell you what the charges are being brought against you, read your rights again, and then may offer bail. Preliminary hearing is very similar. It's a proceeding before a judge in which three things need to be decided. What was the crime that was committed? Was it committed within the jurisdiction? And are there grounds to believe the defendant committed the crime? So you see a lot of this in the show Law and Order. Now, an information or an indictment is something that is generally done at the level of a felony crime. Okay, so if somebody has committed a misdemeanor, you're not going to have an information or an indictment process. We in Minnesota have an indictment process. I believe it's Louisiana, maybe Alabama. They have an information process. But anyway, at the end of the day, they're a little different, but they seek to obtain the same thing. The information is a process where some states will have a prosecutor seek to continue a case against a defendant by filing a written accusation with the court. An indictment, on the other hand, is a process where a grand jury hears the evidence against the defendant before the prosecution can proceed. An information or an indictment is ultimately looking to make sure, do we have enough evidence here against the defendant in order to proceed with this charge? Okay. An arraignment then is a first appearance of the defendant before the court that has the authority to conduct a trial. Now, the defendant must enter a plea, either guilty, not guilty, or no contest. And I put down here a no contest may result in a conviction, but if the defendant is facing possible criminal and civil charges, a no contest plea will prevent them from having to be sued civilly later. Okay? You don't see too many of those, though. Adjudication, fancy word for trial. We also have the sentencing, which can be consecutive or concurrent. And then we have corrections. During the corrections phase, you have either parole or probation. Parole is when a defendant spends some time in jail or prison and then ends up coming out, spends the rest in as a on probation, whereas a probation level or a person with probation spends no time in jail or prison, but they are supervised. They have supervised conditions. My time is pretty much up, but I want you folks to make sure you know what due process is, and we'll chat later. Have a good week.